Hello, everyone, and welcome to video 317 from the Legal Studies guy. Quote in our last video was a quote about success and about, success is when you fail, but don't give up, enthusiasm. And got another quote about success. No idea what Bobby answer is. Look him up if you want. But success is where preparation and opportunity meet. And I guess that following on from the last one, the idea that if you do fail and maintain that enthusiasm, hopefully you also learn from it. And success is about making sure that you are well prepared and you put your learnings into place and do things in a timely manner so that when you do have that opportunity to succeed, you can take it. This is particularly important in Year 12. Exam at the end of the year, but your assessments throughout. It's about doing that preparation and doing it in a way that is meaningful, not rushed, that is, logical and systematic so that when you get the opportunity to perform, which is your assessments, you're able to and you're able to have success. So, pretty straightforward, but very important. 317 today, our key knowledge is plea negotiations. So centrally, we're talking about what plea negotiations are, and we're focusing on these two things here: purposes and appropriateness. So what are plea negotiations and why do we have them? So what's their purpose? And then when should we use them? And we're going to discuss that appropriateness. So we're going to talk about when we should and when we shouldn't. Ultimately, what are we trying to answer today? Well, what are plea negotiations first and foremost? When are they appropriate? Why do we use them? When do we want to use them? / when do we perhaps want to avoid them? Essentially, we're going to talk about delays in, I think it's point 3110 or time, but one of the really common things that will come up when we talk about issues with the justice system is delays, is time. So trying to get through not just a criminal trial. I mean, a criminal trial can take a long time as well. They can take weeks, but just generally a criminal case, really, really lengthy. There's a lot of statistics out there on time to trial being, getting in some jurisdictions close to 18 months. So thinking about that from when an incident occurs, a year and a half is a really, really long time. Like, think about you today, early in year 12, a year and a half is, halfway into your gap year or your first year at university. So a really, really long time. So where possible, the prosecution, and that's expensive. So where possible, the prosecution loves trying to get the accused person to plead guilty. Because if they say, yeah, I did it, then you don't have to go through all of that, do you? Like, it makes things easier. So what plea negotiations are and what we're going to talk about in a moment is they are a tool, so a device that the prosecution can use to achieve a guilty plea. So trying to get the accused to admit that they did it, to therefore save some of this time and therefore money and expense. So how are they going to try and get an accused person to plead guilty? They can't just ask them nicely. They can't just expect an accused person to be like, oh, yeah, it's the right thing to do, I guess. They have to offer the accused person some form of incentive. So give them some kind of benefit in response for them saying, yeah, I will actually plead guilty rather than go through this long process and go to trial. Now, in Victoria, the incentive that the prosecution can offer are two things: either a reduction in charge to a less serious offence. So it's really important that you understand here that we're talking about a reduction in what the person is being tried for. So a reduction in the charge that they will face court for. So you might, for example, be offered with there's two crimes in Victoria called causing injury intentionally versus causing injury recklessly. Intentionally is a more serious crime. It has potentially a longer jail sentence. Maybe you could incentivize the person to plead guilty by saying, "Hey, if you plead guilty, we'll change it to recklessly, not intentionally." Two separate crimes are causing serious injury versus causing injury. And maybe it's like, if you plead guilty, we'll change it to injury, not serious injury. So incentivizing to the accused person, hey, we're going to give you a lesser charge. And obviously the effect of a lesser charge is ultimately a lesser consequence. That's, a logical progression, but it's really, really important that you don't explain it that way. You don't explain, hey, the prosecution offers a lesser consequence or a lesser sentence. This is something you might have picked up watching American TV shows again, particularly things like Law and Order, where they might run the line of, hey, if you plead guilty, 10 years rather than 15. That's a misconception. Sentencing, which we'll get to, sentencing is fundamentally the judge's responsibility. Only a judge can sentence someone, and a judge is not involved in plea negotiations. They're not a participant in plea negotiations. Plea negotiations are between the prosecution and the accused person. So really important that you understand that the incentive offered is a reduction in charge to a less serious offence, or you might hear in the newspaper sometimes if we talk about someone being charged, they might be charged with 22 offences. Because either in the process of committing one crime, there's lots of little things that they've done that are also crimes, or they might have offended over a longer period of time and therefore can be charged with multiple counts of something. What the prosecution might also be able to offer is the removal of some charges. So where they say, hey, 22 offences, how about we, get rid of 7 of them? Then, these 7 here we won't bother with. We'll drop those. You plead guilty to these 15. And again, the idea is less charges, less things to be sentenced for, ideally for the accused person, therefore less consequence. Also, we'll talk about in sentencing guilty pleas. The process of pleading guilty, showing an indication of remorse, taking the case out of the justice system is going to get you a discount in sentencing as well. So it sort of offers that dual benefit to an accused person. But these are the incentives in plea negotiations: reduction in charge or removal of some charges. Now, what purpose are we trying to achieve? Well, essentially, it's that first one. As I said, save time and money. So the purpose of plea negotiations is get a guilty plea, save time, resolve the dispute, save time and money. What are the benefits? So you can talk about this, you can talk about the benefits in regard to any stakeholder in the justice system. That's a really important point. So a stakeholder is someone who has an interest in the justice system. Examination report's been clear on that. People who have an interest in the justice system are the community. We have an interest in the justice system as a stakeholder because a functioning, viable justice system is important to social cohesion and basically our safety as a society. So we benefit from plea negotiations because by ensuring a conviction, we get offenders getting appropriate consequences and save public resources. So purpose is benefit to the community. Another purpose is benefit to the victim. The victim now no longer has to go through a trial process. They don't have to give evidence at trial. There's not the risk of the person being found not guilty. They're going to get some form of justice. So plea negotiations benefit a victim. They ensure that they get justice. Plea negotiations benefit the prosecution because they can allocate their resources to other matters. So the purpose is then, therefore, benefits the prosecution and also the courts in general and all other court users. You reduce caseload, you therefore limit delays. So, purpose of plea negotiations is to resolve the dispute early in general, and that provides, therefore, benefits to a large number of stakeholders in the justice system. The key skill, though, here is so in terms of key knowledge, purposes of plea negotiations, and you might be asked generally about plea negotiations from much more of an explain perspective, show your understanding of them. But the higher level skill that we need to know is this idea of discuss their appropriateness. Now, discussion is really, really important that we understand. It's a higher level skill, so it's a harder skill, and a discussion is, in legal studies, an exchange of opinions. So think about a discussion is between two people, and they're two people exchanging views on something. So if we're discussing appropriateness, the two views here that we want to make sure we're across are when they are appropriate and also when they're not. So an understanding of both sides of this concept is what a discussion entails. A simple, straightforward question could be something like this: discuss the appropriateness of using plea negotiations to resolve a criminal dispute. So, really general and just rolling out general ideas of when plea negotiations work, but also when they don't. You could also get asked this sort of question in response to some stimulus material, and therefore you're expected to pick out details about, say, the victim or the community, or the time it's going to take to support your answer around whether it would be appropriate or not. Some really easy things you can use when talking about appropriateness of plea negotiations are just listed here. A really, really important one is around ensuring a conviction. So, if we offer the accused person a reduced charge, for example, and they plead guilty, it means we actually convict them of a crime and they get a consequence. Often in criminal disputes, in criminal cases, there might be issues, with the availability or the reliability of witnesses. Maybe witnesses aren't that willing. We've talked about rights of victims, alternative arrangements, that giving evidence can be really challenging. It can be a really confronting process. Victims can pull out. Victims can be unwilling or reluctant to give evidence. If that happens, the case can fall apart. If that happens, then the person walks free. If we can get them convicted of a lesser charge, because get them to admit to a lesser charge, then we are getting justice. So they're appropriate where there are issues with witnesses, and we still want to make sure that we get a conviction without taking a risk of a trial. If there's issues with evidence, other key pieces of evidence, again, we might want to enter into plea negotiations so that we ensure a conviction. So really, really key language there: ensure a conviction. And sometimes, because look, charging someone is the responsibility of police. Sorry, I'll just write down here: ensure a conviction. Charging someone with a crime is the responsibility of the police. In some matters, the police will discuss that with the Office of Public Prosecutions and get advice from them on whether to charge someone, what to charge them with. Sometimes police will just lay charges, and perhaps the charge that police lay might be incorrect. Police might charge someone with murder, and over time, the prosecution might be working on the case and might come to the view that they can't prove intent. They can't prove, or they're not going to get a jury to accept that the person was acting to such a high level of criminality that this was an expected outcome, that this was, intentionally killing someone. And therefore, it might just be appropriate for them to offer the person manslaughter. Hey, can you plead guilty to manslaughter? And as a result, we will get a conviction because the original charge was wrong and we're not going to be able to prove it. So there's some reasons where plea negotiations might be appropriate. Where they might not be appropriate is high-profile cases. I'll talk in a minute about how plea negotiations are presented in the media. And you can just generally answer here, maybe with a bit more sophistication than this, but the public don't generally like them. So, lack of transparency, the fact people are getting less, this whole idea of the public really likes tough on crime, and this idea of lesser charges for someone, it really doesn't go down that well, particularly in high profile cases. You can look at the case of Boris Rostevsky, who pled guilty to manslaughter for the death of his wife. When public perception was pretty clearly that people in the public thought it should have been murder. People who maybe aren't as educated on the difference between those two things. And as a result, doesn't go down well. And the community is a stakeholder in the justice system. So you can pretty clearly say, hey, public don't like them. Public don't like lesser charges. Therefore, plea negotiations are not appropriate, particularly in high profile matters. Sometimes as well, the victim. So the victim might not want the person to get lesser charges, right? The victim might want them to get the highest charge that they possibly can. And the victim might not support getting a guilty. The victim might want their day in court. Now, the prosecution has no obligation to follow the wishes of the victim, but ideally they should let the victim know what's going on, informed of proceedings as a right of victims. And take their views into account if victims don't want lesser charges or charges to be dropped in exchange or to incentivize that guilty plea. So that's where they might not be appropriate. As always, from now on, we need to connect to the principles of justice. If you want to take a moment to try and think about where fairness, equality, and access might fit in here, please do now, with the blank table there. But effectively, quite a lot of good things for both sides from plea negotiations, So fairness for society. If the conviction was going to be unlikely at trial, but we get a conviction, that's better for the community as a whole. That's justice. We know things being justice, things being fair. But if a conviction at trial is unlikely, what if the person didn't do it? And could be a really common thing with plea negotiations and connects into legal aid a little bit. If a person's unrepresented, if you're a self-represented, you can't afford a lawyer, or you haven't been able to figure out how to get access to one, and the prosecution comes to you and says, "Hey, well, you might not. If we reduce this charge, less chance maybe you'll go to jail. Like it's a lesser of, you might feel pressure to just take the lesser charge, plead guilty, and try and move on with your life. And that could be a really, really big issue then with fairness. If you are pressured into pleading guilty for something that you didn't do. So important point there. Also, the accused might make that decision early in the process, and they might not have seen all the evidence against them. So, what occurs at committal hearings with disclosure, which we don't cover as much this year anymore, but again could lead to pressure to plead guilty, and result in convictions of innocent people. Equality sort of missing in the sense of it's not so much a disparity thing, but from case to case, there's no real transparency around plea negotiations. It's all dependent on what the prosecution wants to do. So it's hard to suggest that all similar defendants are perhaps getting the same treatment throughout plea negotiations, particularly, again, if you don't have a lawyer. So there's sort of a link to equality in there. A lot of access stuff. If we incentivize a guilty plea, the justice system therefore moves quicker. Reducing delays is very key to access. It helps more people engage with the justice system because there's less caseload. So that efficiency, reducing backloads, also can help victims engage because they no longer have to give evidence at a trial, which is combative. They just get to engage in the sentencing process. But we know victims might not be accounted for with their views. So are they actually able to engage? If they've got views that aren't taken into account, that's not engagement, so that's not access. And again, if the accused is unrepresented, so coming back to this point here, connects down to here, are they engaging in an informed way? Wouldn't say so. And as a result, might end up accepting negotiations, pleading guilty to something they didn't do. So challenges there. In terms of synthesize, applying it to real situations, real scenarios, just look, it's a link to one here. It's an old case, but if you just Google plea negotiations or plea deals, particularly Herald Sun loves running these, they tend to run an investigation every year or two, basically talking about how many people get plea deals, how we don't know anything about them, and how it's soft on crime. So sort of a bit of outrage journalism about, these bad guys are getting away with things, which doesn't necessarily take into account the idea that people might have been overcharged. People might have been charged with things that they shouldn't have been charged with. And the negotiation is actually, unfortunately, that's sometimes a tactic that can be used by prosecution and police, is to overcharge someone, offer them an incentive to plead guilty, which is probably the charges they should have had in the first place. So sort of these investigations and outrage at plea negotiations maybe kind of avoid some of those issues, but it is worth looking at in terms of how the public perhaps feels about plea negotiations. Look, hopefully, if someone came up to you right now and said, "Hey, I read something the other day in the paper about plea deals," you can really help, guide them through the idea of what a plea deal is. If you watch Law and Order with someone that says, "Oh, can you get offered a lower jail sentence?" You can say, "No, not in Victoria. That's not how it works. It's lesser charges. It's a combination or reduction in number of charges because you truly now do know what plea negotiations are and when they are appropriate." As always, feel free to leave any feedback. But yeah, thank you for watching all the way through.